In the Honorable Court of Civil Judge Class 2nd, Chhatarpur, Madhya Pradesh, suit number 20, year 2020. Ram Sevak, son of Rajaram Soni, is 35 years, residing at Santinagar Colony, district Chhatarpur, MP, versus Narayan, son of Dhanraj Sharma, is 39 years, residing at Santinagar Colony, district Chhatarpur, MP. Pleading order number 7 of CPC 1908, sir, in the matter of plaintiff is owner of plot number 1 and admittedly defendant is owner of plot number 2, but the plots are adjacent to each other. The plaintiff has constructed a house on his plot number 1 and one right side of his house. He has opened 2 windows, has left side and back side of his house. There are the walls of other houses. The plaintiff had no other source of light and air in rear portion of his house, so the plaintiff was constrained to open windows on his right side wall. The plot number 2 is lying open windows on his right side wall. The plot number 2 is lying open and vacant for more than 25 years as defendant of to sell it. Whenever he would get a handsome amount, the plaintiff is enjoyed here and light from their windows, which is according to him minimum requirement for the permanent beneficial enjoyment of the said property. According to plaintiff, he is enjoying the right and of light and air within knowledge and without interruption of the defendant for the last more than 23 years. It is further pleaded by plaintiff that the defendant and purchased his plot number 2 from someone, and at that time his house was already constructed. The defendant, even after purchase of the said house, never objected about the windows of plaintiff. Now the defendant has started construction work and is digging foundation so that on a certain day he will erect walls adjacent to his house, thereby plaintiff will be precluded from enjoying his right of easement acquired by him. The plaintiff has filed the suit for declaration and injunction restraining the defendant from obstructing air and light that he is receiving through windows more than 20 years. The plaintiff has valued the suit for declaration to the turn of rupees 1000 rupees only, as the value of the suit reads, and a court fees of rupees 120 MP state has been paid. In addition, he has valued the suit for injunction to the turn of rupees 400 and a minimum fees of rupees 100 MP state has also been paid.
Good afternoon, sir. Your Honor, the case Ram Sevak versus Narayan, the counsel on the behalf of the defendant needs permission to proceed the court. In the Honorable Court of Civil Judge 2nd, Chhatarpur, MP, SC number 2020, Mr. Ram Sevak, son of Rajaram, age 35 years, residing at Shantinagar Colony, district Chhatarpur, MP, versus Mr. Narayan, son of Dhanraj, age 39 years, residing at Shantinagar Colony, district Chhatarpur, MP. Written statement on the behalf of the defendant to the suit filed by the plaintiff under order number 8 of CPC 1908. Most respectfully, sir. Defendant reading: the defendant has denied all the advertisement made by the plaintiff. The defendant has further stated that predecessor entitled told him in the presence of plaintiff that he had given permission to open windows, but no written document was executed. Therefore, plaintiff had just a oral permission and can be revoked at any time. It was just a permission withdrawn by him before he started digging work on the plot. The defendant further alleged that even if the plaintiff has acquired the easement right, that also it is not an unfettered right. It is always to be generalized so as to enable the defendant to use his property to the maximum. Defendant has also challenged the valuation and court fee.
I would like to tell you some case related to this section in which it has been told that in the matter dealing with the Indian Easement Act 1882. Section 4 easement defined on an easement is a right which the owner or occupant of certain land possesses as such for the beneficial enjoyment of that land to do and to do something or to prevent and continue to prevent something being done in or upon or in respect of certain other land not his own. Page number 12. Indian Easement Act Section 4. So Section 4 of the Indian Easement Act 1882 explains the nature of easement. On easement is a right enjoyed by the owner or occupier of one land called the dominant tenant over the land of another, called the servant tenement. If defines on easement as a right that allows the owner of one land to use another land in a particular way, such as to access light or water. It explains that this right must be lawful and it does not transfer any ownership or possession of the servant land. The easement is a right tied of the dominant tenement, the property benefiting from the easement not to own individual. Indian Easement Act Section 4 Case Law E.K. Burma vs. Union of India 1954. Facts. The case involved a dispute over use of the paveway between two pieces of land and whether the paveway qualified as on easement. Co-decision. The court applied the provision of Section 4 of the Easement Act and confirmed that on easement was a right enjoyed by the owner of one property over the another property for the benefit to the dominant tenant. This case reinforced the understanding that easement are right, not ownership, and must be used to benefit the dominant tenant. Raichand Vanmilidas versus Maniklal Mansukh decided by the Mumbai High Court on August 1945. Addressed the accusation of easement right by prescription under the Easement Act 1882. Fact of the case: the plaintiff Raichand Vanmilidas sought to establish on easementary right over the defendant's property, claiming that he had been using a pathway across the defendant land for a extended period. The defendant Maniklal Mansukh contested this claim, arguing that the plaintiff use was permissive and not adverse. Whether the plaintiff use of the pathway was adverse and interrupted for the statutory period required to act based on easement by prescription. Whether the plaintiff had acquired prescriptive easement under the Indian Easement Act 1882. The court examined the nature of the plaintiff's use of the pathway, considering factors such as the manner of use, the relationship between the parties, and any evidence of permission or acquiescence. It was determined that the plaintiff's use was not adverse as it was conducted with the knowledge and without objection for the defendant. Purani Dheerajlal Amritlal versus Mehta Sankleshwar Aditram and another decided by the Gujarat High Court, January 10, 1975. The plaintiff Purani Dheerajlal Amritlal sought to express on easementary right for over the defendant's property, claiming unrestricted and adverse use of a pathway for over 20 years. The defendant Mehta Sankleshwar Aditram contested this claim, argued that the plaintiff's use was a permissive and not adverse.
So I would like to tell you some case related to the section in which has been told that under section 52 of the Easement Act 1882, section 52 says that where one person's grant to another or to a definite number of other persons a right to door continue to do in or upon immovable property of the grantor, something which would in the absence of such rights is unlawful, and such rights does not amount to the easement or an interest in the property right is called a license. Fact: license is not an easement. and there is a license is grant expressed or implied. So there is only permission grant to the plaintiff in oral permission by the predecessor in title. Section 52 of the Easement Act 1882 defines license. It states that a license is a right that allows a person to do something on another person's property. Under Section 60 of Indian Easement Act 1882 states that a grantor can revoke a license. Related case law, State of Punjab and Oates versus Brigadier Sukhjit Singh. This case was heard 11th June 1993. The case State of Punjab and others versus Brigadier Sukhjit Singh reported in AIR 1993 SC 2146 revolved around the issue of government land and legality of its possession by an individual. Fact of the case, Brigadier Sukhjit Singh, the respondent, was in possession of certain land in Punjab. The state of Punjab and other respondents sought to evict him from the land, claiming that his land was a part of government property. The central question was whether Brigadier Sukhjit Singh had a legal right to remain in possession of the land and whether his possessions could be termed as a legal or not. Legal issues: whether the respondent's possession of the land was lawful or not. Second, whether the government actions of evicting the respondent was valid. Supreme Court decision. The Supreme Court upheld the right of possession of Brigadier Sukhjit Singh. It emphasized that merely being in possession of land without a lawful basis does not automatically imply that the person in possession is entitled to ownership. The court recognized that the government must establish its ownership through appropriate legal mechanism in its seeks to evict someone from land that is claimed to be government property. This case was significant in clarifying issues related to land dispute involving the government and private individual, particularly focusing on the importance of clear evidence of ownership and the processes involved in evicting someone from property. Second, Lakshman Singh versus Urmila Devi and decided by the Delhi High Court on March 18, 2014 addresses issues related to property possession, adverse possession and validity unregistered document. Fact of the case, the plaintiff Lakshman Singh and others filed a suit seeking possession of a property from the defendants Urmila Devi and others. The defendants claimed ownership based on an unregistered will executed by their father Ganpat Ram and asserted their right to the property. Legal issues. Serial number 1. Validity of unregistered will. Whether the unregistered will executed by Ganpat Ram was valid and could confer title to the defendants. Serial number 2. Adverse possession. Whether the defendant had acquired title to the property through adverse possession. Court analyzes unregistered will. The court noted that an unregistered will does not transfer title to immovable property. It emphasizes that for a will to be effective in transferring property right, it must be registered as per the requirement of the Registration Act 1908. Adverse possession. The court examined the defendant's claim of adverse possession. It referred to the Supreme Court decision Brahmanand Puri versus Neki Puri AIR 1965 SC 1506, which held that in dispute between two parties, Moot Court without title, the person in possession, however, the court found that the defendant failed to establish continuous and uninterrupted possession for the statutory period required to claim adverse possession. Conclusion: the Delhi High Court ruled in favor of the plaintiff, granting them possession of property. The court held that the defendant claim based on the unregistered will was invalid and they had not established adverse possession. This case declared the importance of unregistered will to effectuate the transfer of property right and highlighted the stringent requirement for claiming adverse possession. For a detailed analysis, you can refer to the case of Damodar Narayan Singh versus Sardar Hira Singh, decided by the Calcutta High Court on May 6, 2002, addresses the eviction of a son from his father's property. The court examined the relationship between father and son in the context of tenancy and eviction proceeding. Fact of the case, the plaintiff Damodar Narayan Singh filed a suit seeking the eviction of his son Sardar Hira Singh from a property owned by the plaintiff. The defendant's son contested the eviction, asserting his right to reside in property. Legal issues: serial number 1, eviction of son, whether a father can his adult son from his property. Second, tenancy right, whether the defendant's son had any tenancy right or was merely a license. Court analyzes the court referred to the judgment in K. Ramanujam Chettiar versus Arunachaleshwar V. Vastanam, where it was held that the relationship between a father and son is not that a licensor and licensee. The court emphasizes that the Small Causes Court does not have jurisdictions to decide the question of the title raised by the son. It was noted that the defendant's son was not a tenant and had no legal right to remain in the property. The Calcutta High Court upheld the eviction of the defendant's son, affirming the father's right to reclaim possession of his property. The court concluded that the defendant's son was not a tenant and had no legal right to continue residing in the property. The case underscores the principle that a father has the right to evict his adult son from his property, especially when the son does not have any tenancy right or legal claim to the property. For a detailed analysis, you can refer the judgment.
I want to present evidence on my behalf. Plaintiff has examined himself and proved the cessation of construction of his house, which is of 23-year-old, on the date of filing of a suit. The municipal corporation had given permission to open the disputed windows subject to assistance of easement right of neighbor. He has also proved the completion certificate of house, which is also of more than 22 years old on the date of institution of present suit. In the cross-examination, he has denied that he taken any permission for the defendant registered in title who used to visit on his land but never objected about such windows. Plaintiff has also admitted that he has just passed 5th standard and does not know anything about legal aspects. The plaintiff has examined one neighbor who deposed that he has seen the assistance of a windows for more than 20 years. He has denied that the windows are not in use of plaintiff, for the plaintiff is not need for the windows and he has other source for where he is receiving light and air. Plaintiff had examined one engineer who has supported the case of plaintiff and state that if windows are closed, there will be complete darkness in the room of plaintiff. Section 5 of the Indian Easement Act 1882 deals with the prescriptive rights of an easement and defines how an easement can be extended. It provides that the right to an easement can be extended or lost by non-use over a continuous period of 20 years. If the easement is not exercised for 20 years, it may no longer be enforceable unless it can be justified by valid legal reason. In simple terms, this section recognizes that easement rights that are not used for on extended periods 20 years can lose their legal standing. This section provides clarity on how easement can be created, enjoyed, and lost, and how limitation period can affect right or obligation under the law. Page number 5. Indian Easement Act 1882, Section 5, Illustration A and B states that a right annexed to B house to receive light by the windows without obstruction by his neighbor A. This is a continuous easement. A right annexed to A's house to prevent B from building on his own land. This is non-apparent easement.
Thank you, sir. Sir, I want to present evidence on my behalf. Defendant has examined himself and predecessor entitled to support the case. Both have stated that in their presence, the plaintiff had admitted that he would remove the windows when the owner of plot will start construction. Point 2. In cross-examination, the predecessor entitled has admitted that the time of installing windows was not present on the spot, and when he come to know about on the spot and when he came to know about it, he objected to same and plaintiff agreed to remove the windows whenever required. Serial number 3, nothing was done in black and white but everything was oral. The defendant has denied any right of the easement and claimed that he right to construct on his land and close the windows. Under section 15 in the Indian Easement Act 1882, accusation by prescription, independent use of property. Serial number 1, where the access and use of light or air to and for any building have been peaceably enjoyed there within as an easement without interruption and for 20 years, and where support from one person land or things affixed thereto has been peaceably received by another person land subjected to artificial pressure or by things affixed thereto an easement without interruption and for 20 years. Serial number 2, and where a right of way or any other easement has been peaceably and openly enjoyed by any person claiming title thereto an easement and as of right without interruption and for a 20 year. The right to such access and use of light or air, support or other easement shall be absolute. Each of the set period of 20 years shall be taken to be period ending within 2 next before the instituting of the suit wherein the claim to which such period related in contested. Explanation 1. Nothing is an enjoyment within meaning of this section when it has been had in pursuance of an easement with the owner or occupier of the property over which the right is claimed, and it is apparent from agreement that such right has not been granted of an easement, or if granted as an easement, that it has been granted for a limited period or subject to a condition or on the fulfillment of which is to be seized. Case law Ramaswamy Chettiar versus Ayyamuttu Chettiar, which established that for a prescriptive right to be claimed under the section, the use of easement must be continuous, open and uninterrupted for period of 20 years. The case Ramaswamy Chettiar versus Ayyamuttu Chettiar pertains to the application section 15 of the Indian Easement Act 1882, which deals with the accusation of easementary rights by prescription. Section 15 states that if a person has peacefully and without interruption enjoyed an easement for 20 years, the right to such easement becomes absolute. Fact of the case. In this case, the plaintiff Ramaswamy Chettiar sought to establish an easementary right over the defendant's property, claiming that he had been using a pathways across the defendant I am to Chettiar contested with this claim, arguing that the plaintiff's use was permissive and not adverse. Legal issue. Adverse use. Whether the plaintiff used pathways was adverse and uninterrupted for the statutory period of 20 years. Prescription right. Whether the plaintiff had acquired a prescription easement under section 15 of the Easement Act 1882. Court analysis. The court examined the nature of plaintiff use, the pathways considering factors such as the manner of use, the relationship between parties, and any evidence of permission or acquiescence. It was determined that the plaintiff's use was not adverse and it was conducted with the knowledge and without objection from the defendant. The court concluded that plaintiff has not established a prescriptive easement under section 15 as the use was not adverse and uninterrupted for the required period. Therefore, the plaintiff's claim for an easementary right was denied. This case underscores the importance of providing adverse and uninterrupted over the statutory period to establish a prescriptive easement under section 15 of Easement Act 1882. For detailed analysis, you can refer to the judgment available or Indian Canon. With a clear definition of the right being claimed, interpretation of continuous open and uninterrupted, the court clarified that continuous does not mean absolute uninterrupted use, but rather a consistent use according to the nature the right claimed. Then the burden of proof lies with the claimant.
Objection, my lord. Section 25 of the Limitation Act 1963. If a person has peacefully and uninterruptedly enjoyed access to light or air to a building for 20 years, they can claim on easement. Right to a light, the light to receive light through your windows from a neighboring property. This use should be done in a peaceful manner. Owner permission is not required for this use. This section essentially provides that the limitation period will be extended for the time of acknowledgement, giving the creator more time to file a suit. Section 15. Acquisition by prescription, where the access and use of light and air to land for any building have been peacefully enjoyed therewith as on easement without interruption and for 20 years. The right to such access and use of light or air support or other easement shall be absolute. Thank you, sir.
Point to be noted, my lord. The limit fact, sir, this fact is absolutely false. That according to the plaintiff, he has been enjoying his right peacefully and without any hindrance for more than 23 years with the knowledge of defendants. Further facts, plaintiff declare obtaining easement through windows for more than 20 years, whereas the plaintiff herself does not stand by her statement that the plaintiff has been enjoying air and light from her windows from the defendant's plot number 2 for the last 20 years or 23 years, whereas plaintiff is speaking in a completely lie, because plaintiff has been consuming air or light through those windows for only 18 years, because I have purchased this plot number 2 year in 2022 because the predecessor of this land has given an oral permission or the plaintiff has taken consent from the predecessor to get this land. So, there under section 25 of Limitation Act 1963 deals with acquisition of easement by prescription, time 20 years period, but there cannot be complete 20 years whereas only 18 years completed.
Section 25 related case law, T.P. Burma of versus Union of India 1954. Facts, the plaintiff sued for recovery of the amount due from the defendant. The defendant acknowledged the debt in writing, but the plaintiff argued that the acknowledgement was insufficient. The court held that a written acknowledgement signifying the debater's truth not in a formal letter can be treated as on under Section 25 of the Limitation Act. It was emphasized that the acknowledgement must be clear and unequivocal. The case retired that acknowledgement of liability in writing, even in informal documents, can extend the limitation period. M.K. Ramaswamy versus S.R. Ramaswamy 1997. Facts: the defendant acknowledgement are debt due to the plaintiff and argued that the was insufficient to extend the limitation period. The Supreme Court ruled that the acknowledgement must be made before the expiry of the limitation period and must be clearly indicate the liability for the debt. The judgment clarified that on acknowledgement under Section 25 should be clear, specific, and not ambiguous.
I want to something that argument. Another argument of defendant's plaintiff can have light and air from the front portion. The plaintiff was permitted to open windows, therefore no question arises of easement. Under Section 47 of Easement Act 1882 of Exception 2, if the easement is not necessary, then the easement will expire. Under case Joy Joseph versus Jose Jacob alias Tankaran 2010 for Kerala High Court, it has been held that the right of easement can be acquired either by prescription or by necessity, but both can not go together. Further, in the same decision, it has been held that to succeed in a claim for prescription right of easement, the claimant has to show that has open continuous hostile and uninterrupted use of pathways for a period of 20 years. That was a case where pathways itself created by document in 1971 and the suit was filed in 1987. So it was held that there is no possibility of right of being claimed by the users. In the 2010 Kerala High Court case Joy Joseph versus Jose Jacob alias Thamchan, the court examined the defendant's claim of a right of way over the plaintiff's property, asserting both an easement by necessary and an easement by prescription. The court concluded that the defendants were not entitled to the claim easement. Additionally, it was determined that the plaintiff's right over the disputed property has been lost due to adverse possession and limitation. This case highlighted the legal principle that a right of easement can be acquired either by necessary or by prescription, but both cannot be claimed stimulationary. In easement by an access is essential, whereas as easement by prescription is established through continuous and uninterrupted use over a statutory period. The court emphasized that these two types of easement are mutually exclusive and cannot coexist. Regarding Section 47 of the Indian Easement Act 1882, it addresses the extinction of an easement by the dissolution of the right of the servient owner. In this case, the court found that the plaintiff's right over the dispute property has been extinguished due to adverse possession by the defendant, aligning with the principle outlined in Section 47. This judgment underscores the importance of understanding the distinct legal foundation of different types of easement and the condition under which property rights can be extinguished. Thank you.
I want to say something. Section 4 of the easement was referred. A right by prescription was a claim. There was no consent on behalf of the plaintiff that he will remove the windows whenever required. There was no permission sought by the plaintiff for the predecessor entitled for opening of windows in the wall. Thank you, sir.